We're live.
All right, good morning, January 28th, in the Senate Judiciary. We just have Jay Johnson from the Governor's Office and Tucker Jones from DPS to give us a walkthrough of the proposed omnibus safety bill. The purpose of this will be largely for the committee to get a deeper understanding of these different policies, and then we can pick and choose as a committee what provision we want to put into a bill and work on to move forward. And also, I think just for the sake of time and efficiency, since we're not starting with the raise the age topic at the Senate, perhaps we can get an overview of sealing and expungement, and then move on to section 12 and beyond regarding all the smaller policy changes for bail revocation. So if that works.
Sure. I mean, that's, yeah, I was, so anyway, I'm Jay Johnson, Governor Scott's legal counsel. I do want to say it's good to be back with you, to see you all. And so I was invited to come back and speak to the governor on the public safety bill with a focus on policies related to conditions of release, bail, sentencing, as well as sealing and expungement.
Great.
So I hadn't planned on going over sealing and expungement first, but I'm happy to do that.
Whatever, however your presentation is styled, feel free to.
Okay, I'm sort of laid out. It's in the order of our omnibus bill, so that's okay. You've actually flagged the proposals in the draft bill designed to address the issue of repeat offenses. And I'm assuming you're all aware the issues of repeat offenders and the lack of accountability are one of the key public safety concerns among communities in the state. Vermonters do not understand how known offenders can repeatedly be picked up and released in the same day, sometimes multiple times. And the data from last year, because I think we heard a lot about repeat offenses last year as well, has changed little, with about 10% of the current backlog attributable to about 149 people with 10 or more open dockets. So, and the state's attorney's office have more detailed data on, 5 offenses or more. So that, so we have those up from there. So we need to get those numbers down, and a way to do this would be to disincentivize new crimes, violations of conditions, and failures to appear while out on conditions of release and bail. So we had several proposals to build on the work we did last year. Like I said, I'd like to be able to rely on Tucker as my subject matter expert with additional testimony or to help answer your questions. So as I noted last week, we're going to seek to revise current law on revoking bail to make it a tool police and prosecutors will actually use to hold violators to account. We need clear bail revocation standards for defendants who re-offend while out on bail or repeatedly violate conditions of release. So we're talking about modifications to 13 VSA 7575, which is Vermont's existing bail revocation statute. It includes 5 conditions, which the Vermont Supreme Court recognized are based on the compelling state interest in prosecuting those accused of violating its laws. And I think you heard some testimony about the case State v. Suave, which is a 1993 case which considered bail revocation. So Suave does not stand for the proposition that bail revocation for repeated violations of conditions is unconstitutional, but it does require a showing that repeat violations of conditions of release disrupt the prosecution. So we propose to clarify this second basis. So there are 5 bases for the court to decide to revoke bail. We propose to clarify the second basis for bail revocation. The statute reads in part, the right to bail may be revoked entirely if a judicial official finds that the accused has repeatedly violated conditions of release in a manner that impedes the prosecution of the accused. There is no guidance to courts or to prosecutors on what that means. When the court considered this provision in Suave, it used the term disrupts the prosecution of the accused. So I think one thing that we would like to do is change the word impedes to disrupts the prosecution of the accused. And we would use the so that we would, and then we would define the meaning of disrupt the prosecution in 13 VSA 7576. So disrupting the prosecution of the accused actually establishes some standards, and I again would hope Tucker can jump in here if he feels like it's appropriate. But what the language we're proposing would establish some standards for what that means. And it would include, in addition to any other meaning recognized by law, committing a criminal offense or violating a condition of release by a defendant who has been released pending trial for another offense, and which demonstrates that there is no condition or combination of conditions of release that will assure that the person will not flee from prosecution or pose a danger to the safety of any other person or the community, or the person is unlikely to abide by any condition or combination of conditions of release. And obviously this would be a matter of evidence for, when a prosecutor is seeking to revoke bail. So we would articulate a process for bail revocation, which does not currently exist in the statute. And importantly, we would ask the legislature to expressly state its intent that the definition constitutes a compelling state interest. Because the court will not hold a person without bail, even when the person has violated the conditions of bail, without a legitimate and compelling state interest. So there are lots of showings that the prosecution must make, but assuming that they can meet the standard articulated in the definition, we would hope that the courts would consider that sufficient, a sufficient compelling state interest to hold a person without bail by revoking bail. Do you have anything else you want to add there?
Yeah, I have, maybe I could just wait for a little bit and then kind of approach it in a few minutes, come back to it.
Okay,
Right.
is that okay, Mr. Chair?
Yeah, I think, if we want to go section by section, then if I can provide the opportunity for committee members to ask questions, I also will have some questions then. We can do that section by section if that works. I think sufficient time for that. So,
That's right.
committee members, any thoughts or questions initially regarding sections 12 and 13?
Oh, and this is being introduced. Right, I will.
So
I
we
don't
don't
know what we'd be
have,
working from, and I knew that, so I sent my draft to Kayla just because I wasn't sure if that was helpful, but if you guys have something to look at.
Yeah.
Okay.
Yeah. Initial thoughts from folks. So some of my question slash thoughts. So whether it's the word impedes or disrupts, there still has to be that showing that there's a nexus between whatever the violation is and the disruption of the prosecution.
Yes.
Just want to make sure that that would still be a requirement. I think the other piece is, and this would be a small one, but revising the subsection D, that there shall be a hearing to review the bail revocation. And it's for due process, there has to be the bail revocation hearing when bail is revoked or being proposed to be revoked. So I think that would be just one important change. But
Why we did actually add as part of the process that we would require a speedy trial, just like when a person is held without, and that if the court is unable or for whatever reason unwilling to proceed with a speedy trial, that there would have to be a bail hearing, a further bail hearing.
And the other piece I have just in general, defining in statute a compelling state interest. From my understanding, I'm not sure, maybe we do that elsewhere, but I'm kind of confused by us saying what a compelling state interest is when, generally speaking, that's in the purview of the Supreme Court. And so I was wondering if you have any more.
Well, I think as a matter of policy, the legislature is responsible for defining the compelling state interest. What is it that matters in the law through the legislature. So I guess that's one observation. The other would be in the area of violent crime for purposes of hold without, we have added in certain violent crimes the provision that this shall be determined to be a violent crime for purposes of the Constitution. So we have articulated before a standard that would have to be considered by the courts to be the legislature's intent. And that's why I think that it's important to include the legislative intent here, that this isn't just repeated violations of conditions of release. This is with that has the impact of the disruption of the prosecution. And I think what's happening here is that we are seeing a system that is constantly disrupted by the fact that people are not coming to court, they're violating conditions of release, they're being cited and released for those violations of conditions, which are misdemeanors, and the system piles up. There is a compelling state interest in moving cases, if nothing else. But I think that the more compelling state interest is the idea that Vermonters expect that when the legislature is passing any number of crimes every year with any number of penalties, that those crimes are enforced and those crimes are charged and those crimes are prosecuted out. And that's just not happening. So I think that this is what we are, because there is this constant disruption. If the court imposes bail with conditions and then the person violates the conditions of bail, well, is there no intent by the legislature that people's bail will be revoked if they violate those conditions? And what's the point of bail? So I think that would be my, I think that it is important for the legislature to express its intent that this moving forward in this way is a compelling state interest. Do you have any thoughts on that?
Yeah, first of all, thanks, if I may, Tucker Jones and Department of Public Safety. First of all, this is personally a fascinating topic and a nuanced one. And I think there is room for the legislature to opine on its view of certain constitutional terms. But of course, I think we recognize that opinion or that assertion is not an absolute one because it has to ultimately comport with the court's understanding of what the Constitution provides. And so, in another context, the court has said when a legislature defines a constitutional term, it is entitled to respectful consideration as opposed to the absolute law on a topic. So there is that kind of room for a back and forth conversation, essentially, I think, between the legislature and the courts of what, the people mean by this term versus what the court means by it. And as, just as a specific example, what Jay was referencing to earlier, that the Vermont legislature has done this in other areas of bail law. So we're talking about revocation for the moment, but if you can step out of revocation and go over to withholding bail, as you all know, one of the standards for withholding bail entirely is when someone commits a felony act of violence subject to those terms that Ben has in his presentation on all of this. Felony act of violence. So in 2011, single justice unpublished opinion said, well, let's analyze this felony act of violence as it applies to lewd and lascivious conduct of a child. The court concluded there that it didn't rise to the level of a felony act of violence for purposes of withholding. And in 2015, the legislature turned around and passed a law that added a provision to the lewd and lascivious conduct statute that said this offense that does indeed constitute an act of violence for purposes of withholding bail. And the legislature has done that in other offenses as well. Most recently, use of a firearm while selling or dispensing a drug, first degree aggravated domestic assault, aggravated stalking, and second degree aggravated domestic assault. The other offenses in which they've included a provision like this. Now that language comes originally from Section 40 of the Constitution. So it's an interesting provision there where the legislature is saying this is what we say Section 40 means. In addition to that section 40 language being repeated in, what is it, 75,
7553.
A.
Yeah.
Yes, so which is copied and pasted there. So, so there's kind of some precedent in that realm. Now, transferring that to, I think the point that you're getting at, Mr. Chair, of how does that concept apply to the compelling state interest in terms of the disrupting the prosecution when it's a kind of a case law decision? That's an interesting and even more nuanced conversation of like whether they're legally distinguishable. But nonetheless, it's kind of an example of how we do it, how it's been done before. My kind of general point here with this disruption of the prosecution, I don't think that there's no room at all for the legislature to at least examine the standard here, the history in Suave, how the federal government handles bail revocation, how Massachusetts, New Hampshire, Maine handle bail revocation. And my kind of broader point with bringing up bail revocation is that a lot of the issues that we're dealing with now, and this committee dealt with last year with Senator Sears with Act 138, ultimately stem from our relatively unique standard that has gone unexamined for such a long time. Now, that's just kind of a judgment that's the origin of it. I will say, as I said last time, that it's not necessarily the only solution to address, bail revocation, but it is potentially one of the avenues to examine the topic. And there are others which are also legally fascinating kind of topics of how you get at the topic. But this is one of them that, I do think is at least worthy of legislative attention.
Thanks. Any,
Yeah, just to put it on the record that, I understand what Attorney Johnson and Attorney Jones are saying. The court has opined on this, but has not completely opined on 7575 as a whole. They've only really analyzed a couple of bases under the bail revocation law. One of those bases, though, includes repeated violations of release that constitute a threat to the judicial system or integrity of the judicial system under subpart 2. And in that portion, they talk about repeated violations of release explicitly. So in Suave or Suave, Rico Suave, I don't know how to pronounce this case. But in state, I'm just gonna say Suave, the 1993 case, beginning on page 575. It explains that the bare language of 7575 sub 2 providing revocation for repeatedly violated conditions of release, however, without more, does not rise to the level of a compelling interest. Merely because a defendant has violated, even repeatedly violated court orders does not show that the judicial process is in danger. Some defendants will violate conditions of release by continuing to use drugs or alcohol. Their addictions may render them uncooperative and may contribute to their failure to meet conditions. Addictive behavior will make these defendants special challenges to the judicial system, but will not necessarily threaten justice. Addictive behavior may make them more potentially dangerous. Nevertheless, preventative detention of the potentially dangerous is not now constitutionally acceptable. So I read that to say that you can put this definition in. However, just because it's statutory law does not mean it meets constitutional muster. And I would expect that if whatever the policy decision is, if it's to go forward with this language, I think it's reasonable to expect a challenge to that. And specifically because the court has opined on non-compliance with court orders, conditions of release that are violated, and so that those in and of themselves are insufficient to meet that compelling state interest. And as far as the interplay with 7553A and 7553 as a whole, but with A, those, as Attorney Jones stated, emanate from Section 40 of Chapter 2 of the Constitution. So they were constitutional provisions first. that were then adopted in statute. And because of that and the laws that have changed, potentially categorizing certain behavior as a violent felony, since it's already constitutional, I think is a little bit of a different analysis than in this instance where you don't have a constitutional change that's already laid the foundation to make this statutory change. So again, it's a policy decision, but I think it's important for the committee to know that aspects of this language have been adjudicated and have been shown to not meet that constitutional standard. And I would suggest that writing it in statute doesn't necessarily get rid of that standard.
And can you also, thank you, can you also just identify yourself for the record?
Ben Novogrowski from the Office of Legislative Defense is standing because there are no horses.
So I'm just, the only thing
Oh, I
I'd
didn't
like
see
to
it.
say,
It's all good.
one would be, so we're talking about provision 2, which is release in a manner that it disrupts the prosecution of the accused. Section 3, as it currently stands, is violated a condition or conditions of release that constitute a threat to the integrity of the judicial system. From our perspective, that's not the provision that we're discussing today. The court has made determinations about what it considers to be a threat to the integrity of its own system. Whether we agree, I guess, is relevant. But in this case, we are talking about the right to bail may be revoked entirely if a judicial officer finds that the accused has repeatedly violated conditions of release in a manner that disrupts the prosecution of the accused. And we are trying to establish standards for what that disruption means. It certainly, and it includes, our definition does include reference to the elements of the constitutional standard. It is entirely correct, as Attorney Novogrowski says, that we can reasonably expect a challenge. I mean, honestly, the defense bar being the defense bar. But I do think that it's a fair question, as Attorney Jones has said, to raise as a policy matter.
And then if I may, I'll also just add, the definition that's in there, or what a disruption of prosecution is, that's pulled from the federal standard. That's 18 USC 3148 as a starting point for of understanding what what the feds use for bail revocation, but not necessarily the ending point of criteria that would conform to SWABE, among reasonable minds. So it's open to kind of discussion of what that standard should actually be in a way that actually does comport with SWABE kind of in your best judgment. But I did want to kind of start with using the federal language, so there was kind of some clear starting point of how it's applied in other jurisdictions.
And just to respond to that,
Just one quick, committee, any questions for now? I think when I'm looking at the definition and seeing that committing a criminal offense by itself is something that can be considered disrupting the prosecution, that piece gives me pause as to whether or not we can actually say that is a compelling state interest that disrupts prosecution, with there also being a nexus to the prosecution. Any thoughts on that?
Yeah, and that's the type of thing, like you bringing in the nexus language, bringing in a closer tie to what the disruption of the prosecution meant in SWABE, and tying that more closely. I think that's kind of the reasonable type of drafting discussion that is possible here and kind of invited. Because this is just, again, the federal standard to start with. I think there's some interesting conversations we had about nexus. The language that you're bringing up in SWABE is, it's challenging language, and it does raise this nuanced issue of the degree to which, how much room there really is for the legislature to provide greater clarity on what it means that case. This is the con of this approach of getting at pretrial detention, because you have this challenging case law. The pro of this approach is that it's the crux of the issue of why we are having some of the problems that we have in Vermont. But some of the other approaches out there have their own pros and cons. This is just this one.
Ben, you have,
So just a couple of points. One about the federal language. And just for the community's knowledge, the federal constitution doesn't grant as many rights to bailees as the Vermont Constitution. Really, the only restriction within the federal constitution is that bail cannot be excessive. In the Vermont Constitution, everyone is bailable as of right. So that is an expansion where, you might bump up into some tension between federal statutes and using that language in Vermont. So I just wanted to flag that issue. And then also speaking about committing a new crime and Sauve. So I want to direct the community's attention again to 575 and 576 of that case, where it talks about flagrant disregard of conditions may show disrespect for the judicial system, but these violations do not threaten the integrity of the judicial system in the constitutionally limited sense that they thwart the prosecution of the defendant. Moreover, courts are not without recourse in dealing with those who persistently violate conditions. Proper tools include imposition of more stringent terms of release and initiation of contempt proceedings. And I would add, actually, S-195 provided more tools last year of home detention and pretrial supervision as well. But the court goes on to say that the one sanction not available to the court, however, is withholding a defendant's constitutional right to bail. To justify a compelling state interest and thereby render subdivision 2 constitutional, there must be a nexus between the defendant's repeated violations and a disruption. And so there's elements of that language present in this proposal. However, I think how the process is outlined, and I definitely agree that there's room to build out 75. I know that this committee actually attempted to do that last year in S-195 and didn't end up making it out of the Senate. But the way it has to be done has to be very precise and careful. And specifically on that new crime, they talk about that normally you just need probable cause to charge someone with a new crime. And if you are going to initiate a new charge, that's fine. But if you're going to revoke bail to do that, you need a preponderance of the evidence to show that they've more likely than not committed that crime to revoke that bail. Again, because the overarching theme here is you're innocent until proven guilty. That's really what it is. And so if we're going to withhold or revoke your bail, we need a really, really good reason to do that. And right now, the cases that have outlined those reasons really tie it to that disruption of prosecution and that really just repeated violations of conditions of release and non-compliance with court orders on their own is an insufficient reason to revoke bail. So to do that, you really have to work out that language in how you build out the bail revocation statute to account for that, the showings that are necessary, that there would need to be a compelling and legitimate state interest that the prosecution would have to show at the hearing. If you're trying to revoke bail for the imposition of a new crime, you'd have to prove that by preponderance of the evidence at the revocation hearing. So again, is there room to build it out? Absolutely. But it has to be along the lines of, and I would suggest of how the cases have already outlined it. And I do recognize that there's still space. Not all the subdivisions have been adjudicated 75, but this is essentially the best we've got right now.
I mean, my first thought goes to US versus Salerno and requiring that there's no combinations of conditions that can assure the public safety, and generally describing it, the ability to hold somebody in pretrial detention as being something that needs to be narrowed and for extremely serious offenses. And like I said, that's just what gives me pause about having the language of committing a criminal offense being considered a compelling state interest that has a nexus to disrupting the prosecution, which would allow them to be, allow them to have their bail revoked. So that's just my thought on it. But committee, any questions or thoughts so far?
Yeah, I got one. So I'm trying to pick up on the disrupts versus the impedes, so on and so forth. So the problem that we appear to be having is there's give and take on both sides of it. So the problem we appear to be having is we got someone who's out on violation conditions released. And in banking, I think last year was like 83 or 87. Well, a lot of these conditions that they're violating, a lot of conditions released aren't necessarily crimes as we know them. They weren't charged, or they weren't out on violation of condition release. So what I'm wrestling with is, we talk about disrupts or impedes, is rather than to continue this and to continue to backlog the court system and having everybody else have their right to justice ensured, how do we get to that point? That's my concern here. And but we're talking about bail in itself. It all intertwines, I assume.
Right. So, I mean, courts can release people on conditions of release with no bail. They can impose bail so that, you know, you post a bond and you can walk out the door, but then there are conditions of release associated with the bond. And the theory would be if you violate those conditions, you revoke bail and you call in the bond. To the extent that's not happening because we have this very unclear standard, our attempt here was to establish a standard for what we mean by impedes the prosecution or disrupts the prosecution, which is the language of the court. And we have tied it to not just violations of conditions of release or new crimes, which arguably would be a violation of conditions of release, but which also demonstrates that there is no condition or combination of conditions of release that will assure that the person will not flee from prosecution or pose a danger to the safety of any other person or the community, or the person is unlikely to abide by any condition or combination of conditions of release. So that's the standard that we're building in. It's a standard that we use for violations of conditions while we're asking the court to consider what imposing conditions, whether to hold without, right? I mean, it's an existing standard. So I think that this is the direction that we're taking. As everyone has sort of acknowledged, there may be other directions, there may be a supplemental language, but we believe that this is a policy issue that needs to be addressed this year. I mean, what we're working on is additional tools that exist so that we can actually use them in a way that's constitutional.
Senator Wilson.
Thanks. I think my question is for Ben. So if bail is revoked, are we then bound by the hold without bail constitutional standards? Because we're then holding them without bail.
Well, that's a good question. I don't know, to be honest with you,
Okay.
because for bail revocation, it doesn't really say what's supposed to happen at that point. Now, the one thing about the governor's proposal is that it does take the speedy trial language from the violent felony statute, work that in. So that's something that does indicate what should happen. If we're going to hold you, speedy trial kicks in, going to be held within 60 days, unless the defendant waives it, essentially. And if it's not held, then bail hearing and you release with conditions.
That's fair that we don't know. It's an area that hasn't been decided by the courts. I just sort of think in like plain language lay person, if I have taken bail away, I'm now holding you without bail. So it would make sense to me that same hold without bail requirements would apply.
I think you could make an argument. I think that maybe you might get a prosecutor making some motion to say that. You probably would also get a defense attorney saying, no, they don't. We need to have a bail hearing now and let's reassess.
Well, and the reason I ask is because my understanding of the hold without bail language is it has to be a violent, like there's some really strict reasons in which you can hold some. Okay.
Yes.
Right, the court did not determine that bail revocation is unconstitutional.
Correct. Yeah. No,
That's not what I was suggesting.
yeah, bail revocation is constitutional. It just needs the procedure needs to meet a certain standard in order to be done.
Right.
And I would just say that I just have concerns over the proposed definition of disrupt the prosecution and how there might be tension with that constitutional standard. But I do agree, it's completely a policy decision, because that is a policy decision that this committee can go forward with. It's a gray area and there's potential for litigation. That's a policy decision that you can make, but you can also choose to do something different as well.
No, that's really helpful. And I certainly understand that your crystal ball probably is not working today, but I imagine as you start to wade into the gray area of is this hold without, is it not, we might expect litigation.
I think that's a problem.
I guess the defense bar's job is to defend their clients, and this would certainly be an argument they would raise.
Thank you. Please, proceed.
Okay, thank you. So the second thing, I guess I would move on, if there's not more, to universal sealing of criminal records. So I reviewed S12, which appears to mirror the House Pass version from last year. I have not had a chance to do a side by side, so I don't know if there are changes from the House Pass version. So I can't say 100% that that's where we are.
I can save you the time and let you know it's, the request I made was to just take the House passed version, turn it into a Senate bill in the starting place.
Perfect.
So you don't have to spend the time.
Doing science. Great. Okay, thank you. So I see that it includes the concept of super sealing, which is what was in the House Pass version, which is a threshold matter, is actually not logistically possible for the VCIC. And Tucker can speak more to that as he did last year. So this provision is deleted from our draft. I also started with the House Pass version, but I made a few changes. And again, our goal here is to disincentivize repeat offenses. I don't understand why it would be a policy priority to seal the record of a person who continues to commit crimes in the community. So our changes, which are few, would include the deletion of super sealing, the addition of the condition that to be eligible to petition for sealing, qualifying misdemeanors and felonies, there is no ongoing prosecution arising out of a new incident or occurrence at the time of the filing. Essentially, you can't come to court with dirty hands. That's a fairly basic tenet. And we would prohibit the court from deferring the sentence of a subsequent crime of violence against a person. There is a provision in the, what's now expungement, but could be sealing of the record of a person with a deferred sentence. There is a list of crimes now that cannot be sealed. And those include aggravated sexual assault of a child, lewd and lascivious conduct of a child unless the victim and the defendant were within 5 years of age and the act is consensual, sexual assault of a child under 16, unless consensual, or sexual assault of a child and aggravated sexual assault of a child.
Jay, are you on section 15 right now?
I'm not sure what your numbers are. Oh, your numbers are my numbers? Hold on a sec. I am, also where I am is the entire, I mean, it's sort of drafted in the entirety.
Yeah.
And so, with respect to deferred sentences, that's, yes, section 15, thank you. Yes, it's the language in 13 VSA 7041C. So that's existing language. What we would want to see is the addition of, and again, I put this in brackets and sort of for discussion, but a crime of violence against a person for which the sentence is a subsequent sentence. For which the sentence is a subsequent sentence for a crime of violence against a person. So basically, the sentence of a subsequent violent offense would not be sealable, is what we're proposing here. So, and to add that to the list of deferred, prohibition on deferred sentences.
Committee, any questions, thoughts? I think, just before we move on, I think, so just to clarify from my understanding, this would be for a sentence that would be imposed by the court rather than a sentence that is agreed to between the prosecutor and the defender.
Well, I mean, if it's to have a deferred sentence, I mean, that would be agreed between the prosecutor and the defender. I don't know that. I guess that's the case in some cases. I'm assuming the court can defer on its own motion. I mean, I'm not a practitioner. So I would look to others to answer that question. But I would say that to the extent we now take the position that certain records can't be expunged if they're committed because they're bad crimes, I would add to that the repeat violent act against a person. And we define that in so many ways in our statutes, listed crimes, which is incomplete, violent crimes as a matter of prohibited person for the firearms laws. There are just so many definitions. I'm not sure, where we would fall here. So that's why I put in brackets. But a repeat violent offense.
Yeah, I think just, my own point of clarification that would have to come eventually is, for example, if you look up in section 2, the court can impose a deferred sentence for a listed offense in 5301 subsection 7. So, for example, domestic assault. However, if there's an agreement if there's a resolution, plea agreement, and the state agrees to having that domestic assault go under a deferred sentence, that can still happen. However, it's the courts themselves that can't impose that. And so I'm just trying to clarify or confirm in my own head if this proposal would also fall under that same category. And it's not something that we need an answer for now. I'm just getting my own thoughts out there.
Well, I mean, C is notwithstanding subsections A and B, right? So that is C is a list of crimes that says you can't defer these sentences, right? So I guess that's where repeat violent crimes is where I would add that concept into that section.
And crime of violence against a person. It's obvious what that is, but in general, but in terms of the statutory language, how should we define that?
Well, so that's the thing. That's what I was suggesting before, is it could be repeat listed offenses, which is the concept that I've included below in our other proposal regarding the authority of the courts to reduce or suspend criminal sentences. But I think it could be a matter of discussion, obviously. I mean, this is where I think that there are obviously going to be policy compromises, but I think our real goal here is to avoid repeat violent offenses where offenders are released into the community with no consequences.
Committee, any?
I have a question for you. What is a violent offense that's not against another person? Isn't that by definition what violence is?
What is a violent offense?
Well, so the language reads a violent offense against another person. Why does that need to be clarified that it's against another person? Isn't violence by definition against another person?
I don't think that we actually have a spelled out definition of what violence against another person is. But I think that that would be part of, I think that's what was just being suggested, is the idea of having to take a deeper dive into clarifying what that means in statute.
Right. Somebody might say that cruelty to animals is violent offense. Others might say that the violent offenses that we're counting are just the big, 14 plus 3, or whatever it is now. Then there's listed crimes, which is an incomplete list, is human trafficking a violent crime, right? So that's the kind of thing that if you have a repeat conviction for a violent crime, and again, it's a policy discussion to have, what would be in that list? We've already seemed to have agreed that sexual assaults against children are bad enough to include in this list. I think that what we're thinking here, and aggravated sexual assault made the list. But we don't, I think that what we need to consider is repeat violent offense, other repeat violent offenses.
Any other questions? Please proceed.
So third, along these same lines, we're looking to limit the authority of courts to reduce or suspend criminal sentences for repeat violent offenses, as the legislature has already done with respect to expungement of deferred sentences. So here we're looking to address the issue of the repeat violent offender who is convicted of a subsequent violent offense, receives an appropriate statutory sentence, and is then released into the community because the sentence is deferred or suspended. Or a judge later decides to reduce the sentence despite repeat offenses and non-compliance with terms of probation. So we understand that this is a complex issue as it relates to things like sensitive victims, right? For prosecutors and defense attorneys often to reach agreement on the conviction of a person with a violent offense against another person, it's important to secure the testimony of that person. And sometimes that person will not agree to face the person, their offender in court. So there will often be deals made where you get the conviction, you get the sentence, but the person is released into the community on probation, and at least you have the sentence. And the theory would be you can revoke probation and that person can be returned. We don't know what our experience is really, right? I mean, we don't know if that person has their in some cases, they may have their probation revoked and returned. They may be re-released into the community, but we also know that that person then, when they're released into the community, has the opportunity to re-offend, sometimes does re-offend, and you end up with another sensitive victim, and that person is in a loop of actually never serving a sentence, or serving a very short sentence for a very bad crime. And people in the community can't understand why that would be happening. And I think that we have to put a few limits on the discretion of judges to take these actions. And to the extent that they may still do it, would have to make a finding on the record that why they are making such a decision would serve the interests of justice and public safety. So we don't prohibit courts, but we are saying, if you decide that you need to do this, you will make a written finding. So something on the record as to why this sentence serves the interests of justice and public safety.
Maybe any questions, thoughts?
Anything else?
I think my, just before we keep going on, I'm looking at section 19. I think that's a piece that is confusing me. The proposal subsection D, that no event may a court reduce the sentence on a judgment of conviction for a listed crime if the defendant is a prior conviction for one or more listed crimes.
Right.
So is that suggesting then just an automatic max penalty?
So the court, so does the court typically get involved in determining the length of the sentence? I mean, there is a process for that, right? You have people who would go to jail for a certain term. Then we have provisions in our laws about minimum and maximum terms. We have a probation system. We have a parole system. The court typically, we think, is not getting involved in the middle of a term to reduce that sentence to something that wasn't anticipated by the first sentence. But that is happening. And this is why I think that we are asking for this provision. It doesn't suggest maximum sentence. It just says the court won't intervene to reduce the sentence.
Yeah, if I may add, Mr. Chair, this is in relation to motions to modify sentence after the sentence is already.
I think perhaps, unless I missed it, I think perhaps clarifying that it's only for motions to modify a sentence, just because at first glance, when I'm looking at the language and I see in no event may a court reduce the sentence on a judgment of conviction. At least the way I'm reading it is, there's a max penalty and you can't go below that max penalty. So that's how I read it at first glance. So, but
Okay, I understand that if you need clarity or different language, that is fine. I mean, we're willing to discuss the language, but these are the concepts that we're trying to get at.
Committee, any questions before we move on?
And then a waiver of extradition, which would be section 41. So this is an area of interest to me because the governor actually is the only person in the state who can do extraditions. It's a constitutional process. The Office of the Attorney General typically gets a request from a demanding state. There's a fugitive who has fled justice. They know that the person is in Vermont, typically because they've been arrested and either are incarcerated or being detained, or they've been released on conditions or bail. The Office of the Attorney General receives the initial request, and which comes typically from, another governor, and they review the materials. They send it to me, and I review the materials, and then the governor determines whether to send a person back pursuant to the request. The Office of the Attorney General reports that about 50% of the extraditions requested of Vermont are for the return of people who have already voluntarily agreed to waive the right of extradition. So you have a right of extradition. You can say if you have been arrested in Vermont, you can say, I don't waive my right of extradition. Can't send me back without a governor's warrant. Even if they have signed a waiver of extradition as a condition of release in the demanding state. So they're going to be released pre-trial. They agree to sign a paper that says, I waive my right to extradition. They flee to Vermont, don't waive their right to extradition, and there's nothing that we can do other than a governor's warrant, which, it's happening fairly routinely. So our proposal, which a number of states have, this kind of committee, is would authorize law enforcement to return fugitives from justice if they have a waived extradition as a condition of release in another state. So we would propose language in statute to authorize that, which is what we would need to do. It outlines a process for law enforcement agency to ensure the person has signed the waiver, and makes clear a state's attorney has the discretion to retain jurisdiction in a case for an ongoing proceeding in Vermont. Very often a person is arrested because they are committing a crime in Vermont, and it turns out that they're also wanted on a warrant in another state. So that's the provision here would basically allow law enforcement to just take a person back upon the request of another state's attorney from the demanding state, if they have validly waived extradition in that other state as a condition of release. We've also made a few other small changes where I think the intent here is to give governors the time to do the extradition paperwork. So in 13 VSA 5043, hearing and commitment and discharge, in B, sorry, the page numbers. If the judge determines that the arrest was lawful, the judge shall commit the person arrested to wait for, this says, a reasonable time, the issuance of an extradition warrant by the governor. I would say up to 120 days, because extradition paperwork takes a little bit of time to pull together. It's just, that you need a police affidavit, you need identification documentation, you need to have the request from the state's attorney. The state's attorney needs to get that to the governor's office. The governor's office has a process for, getting that to the governor and getting that signed, and then getting it to the receiving state. So it just takes some time. And what happens is people are just released in the meantime because a reasonable time has passed or 30 days has passed. And people are frantically trying to get the extradition paperwork complete, but just miss the schedule, and the court releases the person into the community. So this just gives a governor the time needed to prepare the extradition paperwork. I also am just in that section ask that we put express language, just like we kind of did last year, for when a judge is considering conditions of release is something express, even though a judge can already do this, but just an express consideration that a judge actually consider that the person who has fled justice to Vermont has already fled from prosecution. We are routinely releasing people into the community when they are fugitives from justice because they can be released on bail. They can also be released on conditions. They have already fled justice. I just feel like it's an important factor to consider if you're a judge determining whether to release a person into the community who is a fugitive from justice. That's just the point I wanted to make there. 13 VSA 4955 is also the extension of time. And then 13 VSA 4967 is the additional provision regarding the return of a person by law enforcement. Okay.
Any questions, Commissioner?
Well, what are we eliminating here, Jay? From working on the streets, when I used to pick people up, so on and so forth, there was a fugitive from justice application. And it was like to be quite honest, law enforcement officers didn't want to mess with this stuff.
Yeah.
There was 9, 10, 13 points that had to show up. And so are we saying if it meets this bar, that still doesn't have to happen, that they still get judicial review on this, or how does that work if they're a fugitive already? It's under C1, 2.
Yeah. I mean, it would seem to me, we're not requiring here another year. Basically, if the paperwork exists, if the prior extradition, a waiver of extradition exists, it's been validly executed, it passes constitutional muster in the other state, it would have to go to the state's attorney for review. This doesn't provide for a court hearing. It would just be allow you to release the person, to return the person.
But to still have to have or a warrant on file, NCIC would say deemed or like extraditable.
Yeah, you would have the arrest warrant from the other state.
Okay. Yeah.
And that's, you might pick them up as a fugitive,
Right.
based on the arrest warrant. You might pick them up because they've committed a crime, you realize they have an existing warrant, but yeah, you'd have the warrant and you would have the waiver of extradition, in order to be able to just return them.
A much more simplified process.
Yeah. Finally, and this isn't a statutory proposal, is, there is a proposal in the works. I don't know if the House is considering it regarding redefining recidivism. We did not have a strong, we do believe that our definition of recidivism needs to be modified to at least make it a more useful metric. And I know State's Attorneys and Sheriffs have requested Ledge Council to come up with draft legislation. I just want to indicate a willingness to work on that. It would be important to get DOC's input, but I think that's a concept that we support. And we didn't propose any specific language here. And that the 2024 pretrial supervision program, which was designed to be a statewide program for repeat offenders, was implemented in Orleans County because I think only see $600,000 to do it. So it was implemented in Orleans County at the end of last year. And the governor will be addressing this in today's budget address.
Thank you.
Sure. Anything else you will?
I also see there was also a section about repealing the sunset for.
Yes. So this isn't the repeat offenders. This is repealing this sunset that exists for taking people. So July 1, 2025, if the legislature does nothing, law enforcement will be prohibited from taking violent or disruptive, inebriated individuals to a DOC facility. It's my understanding, Senator, you probably understand this more than I do, is you might take a person to an ER for some assessment. It would be determined that they just need a place where they can cover, say, for 24 hours. And the only place to take them would be a DOC facility.
And
go ahead.
And I was just going to add, and that assessment isn't done by law enforcement, it's done by, I saw the list here earlier. I can't
Yeah,
find it now, but there's a list of folks who I think are more medically licensed to say, yes, this person absolutely needs to be, you know, watched for a night, based on their intoxication.
Right.
I think that maybe I'm speculating, but I suspect the reason for a sunset on this, perhaps was a concern that uh, perhaps it was just law enforcement just scooping people up and put into a drunk tank for the night, and perhaps there was some concern about that, which I think is reasonable.
I mean, I think that's possible. I think that the idea was perhaps more that we would pivot to a community system of care. I think that our Department of Substance Use has attempted that pivot. It has not been successful. Our designated agencies are not prepared to do some of this work. There is money allocated from last year to do public inebriation beds in the communities. It's not in all 14 counties. Many of our partners aren't implementing or can't implement the programs. So we need a place. That's why we think it's important that the repeal of the sunset be done, but that also, and this is something else the governor will be addressing today, is that we do have a parallel system that is actually functioning in the community for inebriation beds and crisis mental health beds, which, you know, we're making pretty good strides in the area of mental health in the community and crisis response. But we need a parallel, at least parallel, if not conjoined response for people with substance use issues, and that's alcohol and drugs. So that's something that we're also working on in parallel to, so that we're not just saying just drop them off in prisons. We're saying we're also working on community facilities that are more responsive to the needs that we're seeing in our communities.
Yeah, and I think, if I might, I think in Franklin County, PIPs was much needed entity. And speaking to several different folks, it wasn't a matter of money, it was a matter of staffing up there. And so when law enforcement does take someone into what's referred to as protective custody, whether it's through any type of substance abuse, is they want to place them someplace within their community. Those things just aren't available right now in Franklin County. So in their best interest, unfortunately, they're placed in a secure setting, one of the local facilities, which we have in St. Albans. So the sunset on this, I agree with you to address this.
And we also heard this when we had Capital for a Day in Chittenden County, that there is no facility, PIP facility in Chittenden County, and that there's an issue with having to drive to St. Albans to drop people off. So it's kind of there is, you know, I mean, it is not always even a convenient option, but sometimes it's the only option.
Senator Rohovsky, and then we'll take a 5-minute break.
I'm good.
All right, let's take 5, and then let's take 7. Let's come back and